Welcome. This is Ann Guerrero. I lead the Retirement Plan Participant Education Team here at Alerus Retirement and Benefits, and this is another session in what we're calling our 5-question webinar series, and this session is focusing on beneficiary designations and retirement plans, and I'm very excited that today we have John Jeffrey, our corporate counsel, to speak with us today. And so the first of my questions, John, was would you share with the audience your role at Alerus?
Sure, Ann. I've been an attorney since 1983, and for the first 18 years of my practice, I worked in a private setting, did a lot of work with folks with regards to tax planning and probate and probate avoidance. And then back in 2001, came on board with Alerus and then grew with the company and handled everything retirement, primarily qualified plans and dealing with those types of tax issues and ERISA.
Thanks. We're so appreciative to have John helming the department and making sure that we have all the information we need to assist our retirement plan participants. And the reason we focused on this topic, it is of interest to almost all the participants we talk to. And so John and I had a chance to talk a little bit about the topic and the importance of beneficiaries, naming beneficiaries correctly in your retirement plan. So John, we did talk about what are the 2 ways that assets pass at death in these retirement plans that our participants take part in.
Sure. So I think, you know, as a starting point, folks need to keep in mind that there's these 2 broad categories of how assets pass down a generation at the time of our death, or to our spouse, or to others at the time of our death. And there's only 2 ways. So it either runs through probate, which is a legal proceeding that's controlled by your will, or the other alternative is a non-probate transfer, or what I generically refer to as an automatic arrangement.
And, you know, that's probably an unfamiliar term to most of our listeners, John, so could you expand a little bit on what do we mean by automatic arrangement?
Sure. So by automatic, what's happening is the law permits individuals to set up arrangements in advance to control a transfer of ownership at the time of death. But those are specific. They're not controlled by the will. They are related to a specific type of arrangement, for example, a retirement plan. And the important thing there is that overrides the will. That comes first, and then only in the event that there was no arrangement whatsoever, then it may have to run through probate, and then the will is going to control the probate process. So the automatic arrangement, and this is not unique to retirement plans. This comes into play with IRAs, with insurance policies, with bank accounts. These are ways that individuals establish beneficiaries, and those beneficiary designations control at the time of death.
John, could you give us a short example?
Sure. So I think sometimes people have this misconception that if the will designates who is supposed to receive your assets, that the will is going to control. But let's say, for example, in my case, I have 3 kids, Jake, Noah, and Sarah. If my will said that they're going to share each 1/3 at the time of death, but then my 401k account had only my son Jake's name on it, at the time of my death, then that account is only going to Jake. It's not controlled by the will, and Noah and Sarah don't receive anything. And so that's, I think, an important thing for a lot of our end users to understand, that this arrangement, you know, trumps, so to speak, anything that your will says isn't going to come into play here.
John, thanks. I think you made that crystal clear. That was a really helpful, very typical example. And speaking of typical, so my team, we're always helping plan participants enroll in their plan, and when we're doing education, we're always reminding plan participants, keep your beneficiaries up to date. So getting back to sort of that typical participant, what do they need to consider when thinking about naming retirement plan beneficiaries?
I would say that two things. One, I can't reiterate enough the fact that the beneficiary designation is the boss, so to speak. That's going to control how this asset passes at death. And because of that, then you need to be aware of, any change that might happen in your beneficiary situation. And oftentimes that's related to some change in a family structure. So, for example, when I had my first two children, Jake and Noah, I named them as beneficiaries. When Sarah's born, if I don't add her as a third beneficiary to the account, I just kind of forget. Then at some later date, if it was just naming Jake and Noah on the account and I die, now that account just goes to the two of them and Sarah would get nothing. So, as you have new children, always important to make sure that your beneficiary designations are updated. Likewise, if a beneficiary dies, always important to update beneficiary designations at that point, because this is another thing that folks sometimes misunderstand. They think that the child's share automatically goes to the grandchildren, for example, and that's not the case. Normally, the way that beneficiary designations work, it requires the beneficiary to survive you. So in that example, if Sarah predeceases me, I need to go in and change my beneficiary designations to put my grandchildren on for her share. Otherwise, they're not going to get anything. And then the final big area that affects a lot of participants is divorce. Now, there too, in a lot of plans, there's going to be a standard provision that says divorce, wipes out the beneficiary designation, but not wise to rely on that. And keep in mind that even if that provision exists in the plan, there may be other beneficiary arrangements where that doesn't come into play, like IRAs or life insurance. So if someone does go through a divorce situation or has a spouse that dies, another important time to take a look at your beneficiary designation.
John, you've just shared so many really, really helpful ideas for all of our listeners to consider. And my final question, and you and I talked a little bit about, how this should be part of participants' entire estate plan, but what action steps or what would you encourage, in conclusion, our listeners to consider around this subject?
Well, I think, the important thing is to, first of all, have a plan. Sometimes people get intimidated by the word estate plan, but, this is just a game plan, understanding, what you have in the way of assets, who you want to receive those assets at the time of death, and then most importantly, what we're talking about today is the method. How are they going to receive them? Is it going to be as a result of beneficiary designations, or is it going to be a probate asset? And here's where you need the help of an outside professional. So once assets become large enough to, get your attention, I think at that point it's important, to have that game plan, whether you call it an estate plan or what have you, and that you work, either with your accountant or lawyer to look at the overall picture and then make sure that your beneficiary designations in the retirement plan are coordinated with the rest of your assets so that, the folks that you want to receive the asset actually receive the asset at your death.
John, I wanted to thank you so much for sharing your wisdom and knowledge with us, and I think that last point that you hit on, how important it is to spend some time at the front end, consult experts to make sure that your wishes and intentions are carried out. So that concludes this session, and we're encouraging everyone to please stay tuned for additional sessions in our series of webinars. Thanks a lot for attending.